And going back to what triggered these investigations, in this case, evidence was tendered that there were extensive and heavy communication traffic in the Twitter accounts of the first accused person, and that even after the accounts were closed, that he could open other accounts for purposes of communication with other group members. The ideologies and discussions all revolved around the activities of terrorism organizations. I am satisfied that the prosecution approved this charge against the first accused persons to the required standards, and that the acquittal of the other accused persons earlier does not in any way weaken the case against the first accused person on this count, as the membership of that group was not a group membership, and that each accused person was charged separately and not jointly. As regards the second accused person, I note that from the evidence presented by the prosecution that she was the wife to the first accused. I find that there were videos and that were played before court which were said to have been Arabic, and the court finds that even when they were played during cross-examination, the same were not translated before court. The witnesses that gave evidence in regard to the evidence of what was found, or the information found in the phone of the second accused person, was not able to explain whether these were just simple photographs from the internet or whether the accused person was a member. I find that an attempt was made by the prosecution to present evidence by calling a protected witness who stated that the second accused person usually preached extremist doctrine at the university, at the Kampala International University. However, our evidence in this regard was quite shaky and unreliable. I find that no sufficient evidence has been presented by the prosecution to prove that the second accused person was a member of the terrorist group. I grant the second accused person the benefit of doubt and acquit her on count number 1 and section 215 for lack of sufficient evidence. And I find that on count number 1, being a member of a terrorist group, the prosecution has proved their case against the first accused person. I find the accused person guilty and on count number 1 and convict under section 215. The accused are faced with the charge of organizing a meeting in support of a terrorist group. The act provides that a person who organizes, facilitates, or assists in organizing or facilitating of a meeting to be 1, the support of a terrorist group, or 2, the furtherance of activities of a terrorist group, and B, that the meeting shall be addressed by a person who professes or belongs to, or professes to belong to a terrorist group, commits an offense, and is liable on conviction to imprisonment for a term not exceeding 20 years. The defense submitted that the prosecution alleged that the organization arrangements of meetings were made and coordinated from a known place, meaning that the prosecution does not know anything about their wild claims. However, it has been observed that the advent of the internet means that terrorists are no longer wholly reliant on mass media to act as carriers and even intermediaries, because the internet affords otherwise an unattainable prominence and meaning to their violence. The internet now presents actors, whether mass, that the accused persons either directly or indirectly organize a meeting in a physical location, but the prosecution has, in this case, dwelt on the issue that these were all organized through social media accounts that were managed primarily by the first accused person. There was no invitation that was found circulating in the accounts for a meeting that was tabled by the prosecution. Also, from their various social media accounts and communication thereon produced by the court, none were produced calling or scheduling the intended agenda for the meeting. As earlier stated, terror organizations tend to operate in top secrecy. With technological advancements, and the expansion of cyberspace and with different computer applications that serve as vehicles and places where meetings can take place. It thus has made it possible for persons to become members of group and advance the activities of a group without ever meeting physically. Section 215. I will grant the second accused person the benefit of doubt and acquit her in section 215 for lack of sufficient evidence. Count number 3 is a charge of soliciting for that the first, I will, in conclusion, the second accused person, Nuseiba Mohamed Haji, is acquitted on all the charges under section 215 for lack of sufficient evidence. The first accused person, Mohamed Abdi Ali, alias Abu Fidaa, I find the prosecution has proved the case in respect to count number 1, count number 2, count number 4, 7, and 8, and is convicted on those counts. I will grant the first accused person the benefit of doubt, and I'll acquit him on count number 3, 5, and count number 6 under section 215 of the CPC for lack of sufficient evidence. That's a judgment of the court.
Your Honor, number 3 is rehabilitation. We believe, Your Honor, the same has since been achieved. Wish to pray for time spent. Your Honor, number 2 is deterrence. Your Honor, having lost the match that he has lost in his life, Your Honor, it's only a fool that will wish to commit the same offense. And indeed, the accused person isn't a fool. The prosecution has confirmed he is an intelligent person.